questions.
Thank you very much, and thank you very much for the invitation. I'll actually use, if I manage to do so, less time than I need, because it's afternoon, it's the middle of the night in Australia, and I don't know what happened, but I came from Paris, and for some reason it's 2 hours behind here. It used to be 1 hour behind, but I suppose that's part of the modern world. Britain is falling back. The other thing that occurs to me is we've just heard someone from Ireland asking a really good question. If you were in Ireland, perhaps, but certainly if you were in any civil law country, the first thing you would ask in relation to law reform commissions is, why do you need them? A bit like the peasant that's asked his way, as a tourist asks a peasant in Ireland directions to a particular place. And he said, the answer was, if I was going there, I wouldn't start here. So the question is, if we were back in, what was it, 1965, but with all the current conditions of the complexity of the modern world, would we have law reform commissions, or law commissions, as you call them here? You'll forgive me if I call them a law reform commission, because that's what we call it in Ireland, because we wanted to make it different to the English one, even though the act was almost exactly the same, but it was 10 years later. So I think we got some of that right. I hope what I'm going to say to you is not too simplistic, but it's hard to get the balance between the kind of in-depth academic analysis which perhaps at this time of day will drive everyone to sleep, and at the same time make it simple enough to those who are not necessarily familiar with law reform. It seems to me that there are three perspectives on law reform. One is the issue of substantive law reform, that is to say the changing of the laws related to trusts, family law, or whatever esoteric subject with which you're concerned. The other aspect, which hasn't been mentioned much today, is the question of statute law revision. Countries that had the benefit or the hardship of having visitors from the United Kingdom for several hundred years also had to inherit a substantial amount of law. So in Ireland we had to spend a lot of time getting rid of British laws, but we didn't do it until relatively recently. And then the third dimension of law reform, from my perspective, is the reform of the form of statutes. And that involves, in the common law world, consolidation and amendment and revision, and coping with the fact that legislation is frequently amended, and as it's more and more frequently amended, it becomes impossible to read. So it becomes necessary to consolidate legislation. This is a long process whereby some poor person has to go through all these complex amendments, stick them together. They're much more sensible in Australia, and I suspect New Zealand, where this process is done by means of reprinting the legislation. It doesn't go through Parliament, and the chances of, if it's done properly by someone of the right standard, there's not going to be a mistake. So the third dimension is making sure legislation is clear, and this is also a type of law reform. In the much more sophisticated civil law world, legislation is set out in codes. So the process of keeping that up to date is part of the way things are done. Like everything else in the UK and the common law world, it's different and a little unusual. Just very quickly, for a long time in Ireland, from independence, from 1922 up until the 1960s and certainly the 70s, there was a tendency simply to copy British law. So we just literally took it, cut and pasted and put it into Irish law. But conditions changed in Ireland. Some ways the morality hasn't changed, but in commercial terms lots of things have changed. So the system has moved apart. And this then became necessary to look at the stock of legislation. And one of the jobs I had in Ireland was to take on the responsibility of reviewing the stock of legislation that we'd inherited, both from parliaments in Ireland and the UK Parliament, and getting rid of things that weren't necessary. When I got the job first, the Attorney General at the time and the Prime Minister was very keen on this, and so there was great promises of resources. But unfortunately there was a change of government just after I got the job. And the new Attorney General was not remotely interested, and the new Prime Minister was sick of hearing about the Attorney General's office, because at that time the only thing the Attorney General's office was known for was hiding or losing paedophile files. So the new attorney called me in and he said, "What are you doing?" And I explained to him. And he said, I explained to him also about better regulation, you know, the European Union's policy on making laws better, and I explained to him about impact assessment and consultation. And he said to me, "Look, all I want is to get rid of all those old laws on whipping." I said, "What? Did you not hear me?" I said, "But attorney, this was not like guest minister where you could actually argue rationally." He said, "Are you not listening to me? Get rid of all them old laws on whipping." So I went off feeling rather whipped, and knowing perfectly well that all the old laws on whipping were gone, I had a relatively easy time. But in order not to have to do all the work myself, at the time I was lecturing, brought in 6 of my prettiest students, I hate to say, because they're also the cleverest. And women tend to be more careful about these things, and they did a fantastic job, and I sat in the corner looking for the laws on whipping, because after all one must do what one's political masters tell one to do. Law reform commissions are curious phenomenon, because after all they're something that operate slightly outside the normal political system. After all, if you have a parliament, what do you need a bunch of retired or out of work judges looking at the law for? But nevertheless, this is a phenomenon that has developed in the common law world. And one of the characteristics of these type of organizations is the closer they are to government, the more likely they are that their work is going to be listened to. So the question of independence is a very difficult one to manage. On the one hand, you have to, this is a really lawyer's thing, on the one hand, you have to try and do things that are really important and are necessary and which no one else will do. And on the other hand, you have to sniff the wind and see what's going to be politically achievable. And the experience seems to be, empirically, that the law reform commissions or the law commissions that manage that tension best are those that work closely with government, consult with government, and are able to have programs that are relevant to the needs of government. The Lord Gardiner, I think it was, in the House of Lords introducing the Law Commission Bill, said that things do not get done unless it's somebody's job to do them. And with that he then argued the case for a law commission, and so it was established. But looking at it from the civil law point of view, you wonder, well, you know, this is the work of Parliament. Why do you need this separate body? On the other hand, as I understand it, the development of the Law Commission concept was that it was the type of body that could look specifically at what we might call lawyer's law, technical laws, that no one else would be bothered with or anything else, or would be concerned about. But that sort of raises questions then about the effectiveness of parliaments. But nevertheless, it developed. The Attorney General, Declan Costello, at the time was also a Member of Parliament, in introducing the Irish Law Commission Bill 10 years later, said that the activity of reforming laws is something which requires legal knowledge and expertise if they're to be satisfactorily to be effected. Now, if ever, looking at that from an economist's point of view, we think if there was ever a perfect vested interest argument, that was it. In other words, that only fellows that have been called to the bar, or perhaps in very exceptional circumstances, people that are solicitors, certainly not academics or anyone else, can go anywhere near reforming law. And really, the only people who can reform the law are judges. Fortunately, this has begun, I think it's changed quite a bit. And to be to ensure that I didn't say something that would go back to Dublin and result in me having my passport withdrawn, I did send my draft to the Law Reform Commission and said, would you, to a colleague, would you mind casting your eye over this? And it largely survived, but he corrected me on a few important points. One was, I said, you know, why don't you have economists and people who have analytical skills and everything else? And I was corrected by being told that there were people with social science skills and that kind of education. And he also said to me, well, why wouldn't you include police officers and others? I think that perhaps is the way forward for the future in relation to law commissions, if you need them at all, is that they should be a much more diverse group of people. And my colleague from New Zealand and I had a quick chat beforehand, and it's during these conversations that you really learn something. And he said that he questioned the issue of having judges, because quite rightly so, the only law judges know, and by now nearly all of my contemporaries in university are judges, the only law they know is the law which they have issued judgments on. You ask a judge who's in the High Court dealing with criminal matters about competition law, he would say, oh, those foreign things, don't know anything about that. So I'm not so sure that judges are necessarily the best people. Perhaps a mechanism whereby you have a much more diverse group of people undertaking the work, the analysis, and then having it perhaps reviewed by a body of judges might well be the answer. One of the strengths too of law commissions is, as it came out through the last speaker's presentation, is that law commissions have a kind of independence in that they are not necessarily tied to the government. And during consultation processes, people can be much more open speaking to law commissions than they are when they're talking to government officials. The trouble is, if you're dealing directly with officials, they have their own agendas. They're also very conscious of the political agenda. So there is this integrity and there is this trust associated with law commissions, which is something where I think law commissions do add value. And Ireland has been very successful that way. The law commissions have been very independent. They're independent in the sense that the government doesn't say, here's the results we want to achieve, go figure. It's left to the Law Reform Commission to analyse the issues and to consider them in a rational, objective, empirical way. It's not a question of, you know, we have to do this because of that constituency, or we have to achieve this because we don't want to offend those persons. It really is a very scientific approach to law reform. And in that sense, it is, law commissions are very useful. Perhaps an alternative approach would be that parliaments should be composed of educated people who can make rational decisions and can read and write. I'm slightly alarmed by what's happened in what's happening across the world when I look at people with red baseball caps saying, "Make America Great Again," and I see what's happened to poor old UK. Brexit. Would you have had such a result if you had different type of people in Parliament? Back to the Law Commission, back to the law reform stuff. You have to ask yourself, if you had a different type of Parliament and a different type of political system, would you need such institutions? But we do, because that's the way things are. And the question then is the value added by law commissions, and the question, the extent to which, as well as independence, the outputs of law commissions are implementable. Those law commissions, as I've said earlier, that work closely with their governments are more likely to get the results needed, in other words, legislation implemented. Ireland has been very fortunate in that something like 200 projects have been, I can be corrected by my colleague, where working papers, issue papers, consultation papers, and draft legislation, something like 80% have been adopted by Parliament and continued with. And usually they are so carefully crafted through the consultation process, through the research processes, that when they go to Parliament, they're not subject to the same kind of political infighting that, for example, a private member's bill. If a private member or if a minority party produces a bill, no matter that it is unanswerably intelligent, it probably won't be accepted for political reasons. Whereas if something has come from a body with the integrity of a law commission, it is more likely to be enacted. As far as independence is concerned, my understanding of that is, in essence, that it is intellectual independence. In other words, the law commissions are not being told what to do. Now, having said I wouldn't talk too much, I've now lost track of the time. Am I nearly there? So I just finished.
Okay.
As you like. Independence, law reform commissions are also a little bit about trade-offs, and there's strengths and weaknesses in this. And for more details on this, you can read my paper. But I just finished by saying that I would challenge the necessity for law commissions, but given that we have them, it seems to me that they do add a lot of value, because they are bodies that are, for the most part in the Commonwealth countries, intellectually independent.